Thank you. David Dunsmuir versus Her Majesty the Queen in right of the Province of New Brunswick as represented by Board of Management. J. Gordon Petrie QC, Petrie, pardon me, and Clarence L. Bennett for the appellant, and C. Clyde Spinney, QC, and Keith P. Mullen for the respondent. Mr. Petrie.
Thank you, Chief Justice. If I could ask the court to turn to page 26 of the appellant's submission. I want to start with what I think is really the nub of this case, and that is the intent and meaning of the legislative change to the Public Service Labor Relations Act. At page 26 of the appellant's submission, I'd refer to section 92 1B of the Public Service Labor Relations Act. This is the law that existed up till 1990. And for the purpose of this appeal, it would have meant for an employee, a non-union employee, and that's what we're talking about here, to grieve, he or she would have had to establish they had been subjected to disciplinary action resulting in discharge, suspension, or financial penalty. Otherwise, there was no access to adjudication, is what they call it in the public sector in New Brunswick. Now, if we could turn 2 pages to page 28 of the appellant's factum, I want to draw the court's attention to section 100.1 sub 2, which is the relevant section in this appeal, one of the relevant sections. And that states that an employee who is not included in a bargaining unit, which is the appellant, may, in the form and within such times may be prescribed, present the employer a grievance with respect to discharge, suspension, or a financial penalty. It's the same wording as in the previous section, except they've removed disciplinary action. So in other words, any time a public servant in the province of New Brunswick is dismissed, suspended, or suffers a financial penalty, she or he must seek recourse under the grievance and adjudication provisions. Now, while we're there, I'd like to draw your attention to section 100.1 sub 4. An adjudicator to whom a grievance has been referred in accordance with subsection 3 shall conduct a hearing, render a decision in respect to the grievance. Sub 5, and for the purpose of my argument, section 97 is the one I wish to refer the court to. Section 97 applies mutatis mutandis to an adjudicator to whom a grievance has been referred under subsection 3, which then incorporates subsection 2. So 97 applies, and then below that, we'll get to those other sections. But then if I could take you back 1 page, sorry to be moving you all over the factum, but at page 27, 97.2.1. And this was brought in curiously in 1990 at the same time 100.1 was brought in to the legislation. 97.2.1 effectively says, where an adjudicator determines an employee has been discharged by an employer for cause, and the collective agreement or arbitral award does not contain a specific penalty for the infraction that resulted in the employee being discharged, I've left out the other words, the adjudicator may substitute a penalty. Now, that was brought in 1990. This court dealt with a similar case in the Eustis case, which was an NB Power employee, where this court said, of course, an adjudicator has the right to substitute a penalty. So 97 is swept into 100.1. which means that an adjudicator dealing with a grievance under 100.1 has the right to substitute a penalty in certain circumstances, perhaps. Now, if my friend's argument, I will just quickly touch on it. His argument is that Section 20 of the Civil Service Act means that the rights of Mr. Dunsmuir and others are governed by the law of contract, which means that they have a right to dismiss an employee not for cause and provide reasonable notice. And the only thing you can go to adjudication on is the length of the notice. That's the government's argument. Our submission, members of the court, is that when you consider the impact of these changes, a non-union employee not only has the right to grieve, has the right to go to arbitration, and has the right to have his or her grievance dealt with by the adjudicator in its entirety. In other words, and we made this submission in front of the adjudicator, Mr. Spinney's argument there was the same as presumably the same he'll make here today, which is, no, once we say there's no cause, that's the end of the inquiry, except for the notice. And we said to the adjudicator, no, clearly you have the right to find out what was the reason for the action. And if it fits the disciplinary mode, then you can grant a remedy, clearly under 97.2.1.
Didn't the arbitrator make a finding at paragraph 45 of his reasons that this was not
I
disciplinary?
know, unfortunately, he made that finding, and we didn't.
That seems to me to be the linchpin of your interpretive argument around 97.2.1, and since he found it wasn't disciplinary, are we really properly in that section?
Oh, I think so. And I say why, Madam Justice Abella, there's nothing in the Act, for example, if you look at 97.2.1, it addresses somebody is dismissed or suspended for cause, but the penalty's too severe. There's nothing in the Act addressing what if there was no cause at all. Now, the government would say, well, then the adjudicator can't interfere with it. Our argument is if you look at 97, you look at 101, you look at the history, I have to ask the following question. Why did the legislature change the Act from 92 sub 1 to 100.1? And if you accept what the government argues, what the legislature meant was to diminish the rights of a grievor, diminish them.
But your argument really eliminates the words dismissal for cause and the presence of a collective agreement in 97.2.1, doesn't it?
Well, 97 is, first of all, on the collective agreement, Justice Rothstein, 97 under 100.1.5, 97 is swept in the adjudicators. So clearly, a collective agreement is not required. The adjudicator can apply it. We are attempting to persuade this court that when you look at the totality of the changes, it means that any dismissal of an employee in New Brunswick, non-union employee, can be reviewed by an adjudicator, and it's up to the adjudicator to determine whether the penalty is just and reasonable in the circumstances. Because if you look, for example, at section 97.2.1 again, talks about what's just and reasonable. Yes, that's our argument. Unfortunately, I agree with the court. Unfortunately, we didn't persuade the adjudicator that it was disciplinary action. And we, to this day, believe it was disciplinary action. But he's protected by a privative clause, so we consider we couldn't attack that. But then the government went to court, and the motions judge, or the judge on the initial application, said, well, he couldn't even hold an inquiry. He couldn't even hold an inquiry because once the government said, we're dismissing you not for cause, the only issue was the length of notice. Now, surely they could avoid I've practiced labor law for many years. I've never seen one employer who said, yes, we fired you because of your union activity. Never. Not one. And that would be the same here. Everyone would be dismissed not for cause, but on notice.
In the case of someone who's appointed at pleasure, are you saying the arbitrator or the adjudicator would still have the power to order that the person be reinstated in his position?
We're actually
Is
arguing.
that contrary to the nature of the employment contract?
I should tell the court, we didn't challenge this from the point of view of the clerk of the court, the order in council appointment. We purposely.
I understand that, but I'm trying to determine what is the scope of Section 97 2.1. It has to be read in the context of the whole act, and it's obvious that that section is there basically because the employees it deals with are generally covered by a collective agreement. And this is why those that are not are said to be treated mutatis mutandis, which means, it seems to me, you have to pay attention to the nature of the relationship that they have with the employer.
Correct. I mean, you're correct on that, but you see, if the court agreed that the cumulative effect of these sections means that a public servant who's not in the union in New Brunswick can have his or her dismissal reviewed by an adjudicator, that's all we're saying. We're not saying they have to show cause in every case. Can they lay off employees? Of course they could lay off employees. Is that a financial penalty? Likely. But can they do that? But Justice Bastaraj, if the court concluded there's security to an employee of Mr. Dunsmuir's position, the procedural fairness still applies to him. As I understand Knight says procedural fairness applies to the employee who can only be dismissed for cause, which was the old law, and the at-pleasure employee. And therefore, even if you adopted what we're arguing, what we're submitting to the court, procedural fairness in our submission would still apply to Mr. Dunsmuir. See, the difficulty we're trying to address is this. If this court buys the position of the government, there's no protection at all for employees who are terminated by the government for disciplinary reasons, really. But they hide it by saying, oh, no, it's not for cause.
Could you tell me?
But this employee was not in the category of those employees that can only be dismissed for cause, was he?
No, he wasn't. He would have been if you accept that 97-101 means you have to show cause. But our fallback argument, of course, is he's an at-pleasure employee, and the principle of fairness still applies because of Knight. That's correct.
What would you say would constitute procedural fairness in this case? It wasn't clear to me exactly what it was you said he should have been able to do that he was prevented from doing.
Well, perhaps you've opened up. Let me just go through, if I could. I had a quick statement of facts I was going to get to, and that'll answer your question. The appellant was dismissed by the respondent after it canceled a meeting to deal with performance issues. And those are the facts as found by the adjudicator. There's a meeting set up to deal with performance issues. They canceled it. Immediately, they served him with a letter, you're dismissed. And as Knight says, the importance of procedural fairness is that the individual be able to answer whatever the criticisms are and address the issue of retention of his or her job. That's what Knight says, is the importance.
Sorry, you're getting to the performance review meeting that was canceled.
Yes.
There had been three, I think the adjudicator pointed to, incidents up to that point where an inappropriate letter had been written to a Chief Justice, where he, against the advice of the department, undertook commercial teaching, and he was late in his file. So don't we have to start earlier? And in each of those incidences, he was advised that there was a problem. Was he not given an opportunity to respond to those?
He was, and the adjudicator found there was no merit to those complaints. That's what the adjudicator found. But this meeting was going to address, allegedly, all the performance issues, the concern of the government, the way he was performing his job, had been set up in advance, and then, bang, it's canceled. And momentarily thereafter, he's given a letter that his employment is ended, but not for cause, not for cause. And they provided 4.5 months severance. So, I mean, I would agree with Just Isabella that there were issues in his employment. There's no question. Issues that they, frankly, it seemed to me, relied upon to take the action they did. But he wasn't given an opportunity to address the, I mean, if we had come to the sort of culminating incident, he wasn't given the opportunity to speak to that. And he was not.
But do you recognize that there was the right to terminate without cause and to pay severance?
There's a right, yes, but,
Well,
okay, sorry.
if you say yes to that, and that we accept that there was a breach of procedural fairness, wouldn't the remedy be a term for which payment would have to be made?
No.
Why would that not be the remedy if there's the right to terminate without cause?
Because the purpose of the procedural fairness is to give the opportunity to the employee in question to address the employer, to answer the issues, and try to convince the employer that his job ought not to be terminated. That's the whole purpose of it. Now, does that mean necessarily they'll agree? Absolutely not. But I think to say then the only remedy is the notice period is not correct. He's entitled to a hearing in this case. No, he did not have one. It was canceled.
One meeting was canceled, three
One
were
meeting,
not.
which was the, if you will, the culminating meeting to deal with all of these issues, according to the representation of the government, was canceled at the last minute. And shortly thereafter, he served with a letter through my office that he's terminated. Now, that doesn't sound like fairness to me.
Would you say that,
There's been no meeting that had been set up, and you have this history of incidents which may or may not have been justified. Simply send a letter to him saying, on notice, job is vacated. And that posing a formal structure which serendipitously turns on the fact there was a performance meeting set up and canceled. Why couldn't the government simply have sent a letter, given this history, saying you're not the man for the job, we're giving you notice, we think this is adequate, it's not, we'll fight over it.
Well, that's not what this court said at night. That's my only answer to that. This court said, Justice LaRue Dubé clearly said, an employee at pleasure, a government employee, public employee at pleasure is entitled to the opportunity to know what the allegations are and to answer them and try to persuade the employer to take her back.
But Knight
just to
was a
send a
very-
letter, there's no hearing, there's no representation, there's nothing.
No, but Knight was a very different factual situation. Nobody says that an employee at pleasure isn't entitled to procedural fairness after Knight. The question is, in this case, you're dealing with a senior employee, you're dealing with a series of incidents. Has the message not been conveyed on both sides?
Well, there's certainly a message that they were unhappy about some of his activities. There's no question about that. And would I,
The unsuitable,
pardon me?
suitable skill set, or whatever the euphemism
Well,
was.
they didn't say that. No, they said you're talking about things, doing things that's just not suitable for a person as the clerk to do. And you want to go out and earn some money on the side, that's not appropriate and so on. But there was never any issue. Honestly, the issue was never he wasn't competent to do the job. He certainly was competent. Would I have been happier had he done other things and not done certain things? Absolutely. I mean, I'm not here to try to bamboozle the court, but I am here to say, then, if I can get back to the first argument, what was the purpose of amending the Public Service Act to do away at 97.2 and bring in 100.1? And we say the purpose had to be to enlarge the jurisdiction of an adjudicator dealing with a non-union employee, to enlarge it, not to restrict it.
It wasn't to transform the non-union employee into a union employee. It must be interpreted in the context of the actual relationship that exists between the employer and the non-employee, the employee.
Yeah, we're not trying to turn them into a union employee.
Well-
No, we're not, Justice Pasteurek, please. That's not what the argument is. What we're saying is, let me give you an example. The Canada Labor Code says that an employee, non-union employee dismissed, has a right to grieve the justness of his or her dismissal. That applies to the trucking industry and you name it. And they can seek arbitration. And they do. Now the question is, does that mean an employer in that industry can or cannot dismiss an employee of that sort, not for cause and on notice? Or does the employee have the right under the Canada Labor Code to challenge every dismissal? And all we're saying here is surely the amendment to the Public Service Act was intended to enlarge the jurisdiction of an adjudicator dealing with these non-union employees.
But is the adjudicator not still stuck with Section 20? It says, it provides remedies. It provides the ability to present your grievance, but it doesn't say what the adjudicator can do in a particular situation. And Section 20 says specifically it's the contract. So in saying I have the full sort of panoply of powers that I might have in a situation where a union contract, for example, gave me the power to go into the merits, surely Section 197 don't really answer that question.
Well, 97, Chief Justice, I've got to say this. Surely it's not debatable that if an employee is dismissed, a non-union employee is dismissed and files a grievance, seeks adjudicative remedy, that the adjudicator can determine and hear evidence on what was the real reason for the dismissal. You can't hide behind cause, because otherwise why would 97.2 provide the adjudicator the right to substitute a penalty?
It applies mutatis mutandis, but if you have a contract and the basis of that contract is dismissal at pleasure, then it might well, I think, not be possible for the adjudicator to go into that. At least that seems to me a common sense inference to draw, and so I put it to you.
Yes. Yeah, everybody puts it to me, but the problem, I'm used to that. The problem with that is then you're emasculating, you're destroying. It's a destructive interpretation to the rights of employees.
Before you can emasculate, you have to have something to take away.
Did 100?
And I'm at that prior step. What's there in the beginning
Did
conferred by the legislature?
100.1 not enlarge the rights, not only enlarge, did it not compel employees, non-union employees in New Brunswick, to seek a remedy through grievance and adjudication if they're dismissed? That's point
Says
number.
you can present your case, and then the law kicks in, whatever it is. Here, the law happens to be the law of contract, one could argue, and that contract is an at-pleasure contract.
But I'm sorry, but I won't back off on this. That effectively means that 97 is meaningless for a non-union employee. Because let's just assume the employer is not being totally candid in the reasons. It really is a disciplinary dismissal, as we used to have to prove it was under the old Act. Let's assume that just for the sake of this discussion. What you're telling me, Chief Justice, is the adjudicator doesn't even have the right to go there to determine. See, the first decision of Justice Stevenson, or Adjudicator Stevenson, it's unimpeachable. All he's saying there, I have the right to hear the evidence to determine what was the nature of this dismissal. Unimpeachable. In our submission, of course. Unimpeachable. And yet, apparently, that's unacceptable. According to the applications judge, he couldn't even do that. And apparently, the Court of Appeal, he couldn't do that. What he had to do was say, oh, Mr. Employer, thank you very much, but you say there's no cause? Okay, all you can do is look at the notice period. So 97 is rendered unenforceable, or whatever the words are.
Well, I'll just ask one more question, and then I'll let it go. But do you deny that he has to apply the contract law?
Here's what I deny. I deny that Section 20 of this, I was involved in this Flieger case that they've cited. Interestingly, Madam Justice Dubé's dissent, it's the only one to agree with me. That was another civil service issue. I say Section 20 is subject to any other act. And it's clear on its face, and it is subject to any other act. And the question then is, does the Public Service Labor Relations Act give these people, as part of their contract of employment, the right to challenge their dismissal? The answer has to be yes, it does. They have a right to challenge the dismissal. What do they have to establish? We'd like the court to say they have to establish that the action taken was just and reasonable. But I tend to think maybe there's some thought that there's not total agreement with me on that. So, but they certainly have to show it wasn't disciplinary. It wasn't a breach of the Human Rights Act. It wasn't a breach of the Labor Relations Act or the Service Labor. I mean, as I said before, employers never admit they fired somebody because of their union activity, ever. But that's findings of boards and courts that they have. Sorry.
It's just an interpretation question. You've referred a number of times to what would be the point, why would they bother changing 92.1?
Yes.
Could you tell me whether the provisions, 100.1, et cetera, were in place when you had 92.1?
No, it wasn't. See, 92.1, the effective application of 92.1B was the definition which we have in our, what is this? In our Book of Authorities, in the applicant's Book of Authorities, under tab 25, is the old Public Service Labor Relations Act.
So isn't the argument then, the purpose of those provisions, including 97.2.1, to ensure access to a grievance procedure which wasn't available to at-pleasure employees prior to these amendments, and nothing?
Oh, no, no, I'm sorry, Bill. Can I refer you to page 431 of, this is volume 3 of the Appellant's Book of Authorities, pages 374 to 464.
Sorry, the page number again?
It's page 431 of the third book, volume 3. Actually, I'm having trouble finding the section. There is a provision in the old act which basically says that you will, even though you're not an employee as defined in the act, you do have access to the grievance and adjudication provisions of the act. When it was 97, I'm just looking for that. It's in the definition, page 431, under grievance. And it's under the for the purpose of any of the provisions of the Act respecting grievances with respect to disciplinary action resulting in discharge or suspension, reference to employee includes a former employee or a person who would be a former employee for the fact at the time of his discharge he was a person employed in a managerial or confidential capacity. So that gave these people the right to grieve, which then kicked in the previous provision requiring disciplinary action.
So your argument would be that under this new provision, had the adjudicator found that he'd been inappropriately fired for cause, he could be reinstated?
If you found that if the penalty
order-
was too severe, yes,
he could be reinstated?
correct.
Okay, what could he do if he found he wasn't discharged for cause?
He could say the notice given was not appropriate.
I hate,
He could not order a reinstatement in such cases.
Oh, he could order reinstatement if he found the penalty was too severe in the circumstances.
But if he found that this was not a case of a disciplinary action,
Well, except then we get into the duty of procedural fairness, which I'll certainly touch upon. He can reinstate because, as Adjudicator Stevenson said, it's void ab initio. If there's denial of procedural fairness, the action taken was void ab initio, so he reinstated him.
And you say the notice he wasn't given was the meeting that never took place that should have taken place?
Correct.
And if there had, getting back to Justice Binney's question, if there had never been a meeting canceled and he received a letter letting him go based on the 3 previous incidents, that still would not have been noticed?
I think not. And I mean, I know you won't rely on me. That's what the adjudicator found. That's a finding of fact. If the privative clause means anything, we rely on his finding.
I hate to take you away from all this discussion, but at one point, since in your plea to get yourself before this court, you suggested that our 3 standards of review were confusing, could you help us on standards of review?
Could I
Any
help you?
thoughts?
I'm sorry. You got yourself into it. You get. The only.
I'd be interested in hearing if you can help us.
Oh yeah, no. Well, I could help you to this degree. I'm not sure. In this case, there's a privative clause. There's no. The adjudicator's decision is protected by a privative clause. It's a strong privative clause. And to me, the issue is a level of deference. Do you give deference to the decision or do you not give deference? And I think to get into even the 4-pronged test, you run into problems. For example, relative expertise. Now, let me just give you an example where I think that's a problem. In this case, we had an adjudicator who was a retired Queen's Bench judge, had been a judge for 25, 30 years, whatever. And the application judge, if that's the measurement, he'd been a judge for a year, maybe? And the adjudicator had dealt with all kinds of labor cases. In fact, in that Flieger case, he found against me. That's how we ended up here. And at any rate, that's a different matter. So I think some of those tests, to a practitioner, even an old practitioner like me, it seems to me the real question is deference. Is the decision entitled to deference? And if it is, I go back to the reasonable bear test, which everyone used to make fun of. Is their interpretation one it would reasonably bear back in the early days of these tests? And it seemed to me that made a lot more sense. I know, look, you'll never tie it down so it's black and white and, you pull this lever. I know the difficulty is, but the way it is now, it seems to me it gives judges just this wide a spectrum to do,
Two issues.
Yes.
One is procedural fairness, the other is the interpretation of Section 97.
Yes.
In terms of procedural fairness, do you agree that there really is no deference to be given? Or in other words, that the court should be reviewing procedural fairness on correctness standard?
Only does he have the right to apply the law? Does he have that's the question there. I mean, this court found in Perry Sound that the arbitrator could apply the charter. Well, doesn't this arbitrator have the right to apply the common law of procedural fairness? And if not, why not?
So you say, I'm sorry. So you say that even on an issue of procedural fairness, the court has to defer to the arbitrator?
Well, I say he made a finding of fact. The fact was that they had not provided this gentleman procedural fairness. On that, yes, I think you should give him deference. It's a finding of fact. Now, maybe you'll find the employee was not entitled to procedural fairness for some reason that escapes me, but if you do, that's different. But I think on whether he had or had not received procedural fairness, surely that's...
So in terms of procedural fairness, you're saying that where he makes a relevant finding of fact, that should be entitled to deference, but on the legal approach to what the standard requires and how, what level of fairness is required, that's all legal and no deference on that?
Well, I'm not quite going that far, Justice Rust, because the question I have really that has to be addressed, as an adjudicator under this act, has he right to apply the law? Is that part of the law? Is the duty of fairness part of the law as it applies to a public employer? And if he does have the right to apply the law, but should you interfere every time? It used to be, even if the rule used to be, if it's within the arbitrator's jurisdiction, even he can err in law and still we won't review his decision. That used to be the standard. So I'm not sure, if the adjudicator has the right to apply law, why wouldn't his finding stand? Be given deference.
Started by saying that it's a question of deference or no deference. Do you have any words of wisdom as to how to distinguish between those questions that would call for deference and those questions that would not?
Well, findings of fact, I think there should be practically total deference. And if it's a finding of mixed fact, mixed law, I still get down to, I think it's, clearly if there's a denial of natural justice, that's reviewable, I think, by a court, that's for sure. And I think if there's a decision which can't stand to reason, irrational, the court used words like that before, irrational or just sort of off the wall, but that's not a test I think you should put out there in the law books, off the wall. But I mean, you did use some pretty strong, not this particular court, but previous courts used pretty strong language to say, unless it's sort of impossible or ridiculous, we're not going to interfere. And it seems to me that's where you should be.
Mad, slightly mad, really mad.
Well, it's all in the eye of the beholder, I guess. Any rate. Yes. And that, I always, if there's a privative clause, and there is a privative clause.
And what about in the case of the statutory interpretation issue? We've been talking about procedural fairness now, but in terms of the statutory interpretation issue, are you saying that the deference has to go to clear irrationality before the court can look at the statutory interpretation question?
Because this gentleman was appointed to be the adjudicator under the Public Service Labor Relations Act. If he's off, McLeod and Egan years ago, if he's off interpreting some other statute out there, that's different. But if he's interpreting his statute that gives him or her, I'm talking about an adjudicator authority, I think the same test applies. I don't think it's correctness. Otherwise, this procedure is supposed to be fast, cheap, inexpensive, and binding. Well, here we are in 2007. This man was dismissed whenever 2004, and if he could speak, he would say it's not inexpensive, and it's apparently not binding. That's why we went to adjudication. It just seems that it's on its head again. So,
I'd like to come back to this distinction between applying here the procedural fairness rule and the interpretation of the Act itself, because the adjudicator, it seems to me, would have only the powers that are described in the Act. They're not inherent powers. And if you say this is a common law right to procedural fairness, to a meeting as the one that was canceled, wouldn't you have to go before a superior court for an order with regard to that if there is no such obligation on the adjudicator to determine that issue at all?
But Justice Bastreich, that's exactly what we practitioners run up against. Let me give you an example. Mr. Dunsmuir comes to see me. He tells me his story. He didn't tell me he was an order and council employee, but anyway, besides that, and so what am I to tell him? I know you're supposed to grieve under the Public Service Act. It applies to you even though you're not a union employee. And by the way, in my judgment, you're entitled to procedural fairness. For example, one of the cases that we cite, I think, is a case Judge Stevenson said that the assistant solicitor for the city of Moncton was entitled to procedural fairness. I was on the city side, so I'm quite familiar with that. So I said, you also could go, you could seek a remedy on the basis of procedural fairness. But in my judgment, if we go to court over that, they're going to say, adequate alternative remedy, you're supposed to be in adjudication. I mean, it would have happened. So what are we to do? I mean, you know, you can only walk, your legs can only get so far apart before you split in two. I mean, that's what would happen. And that's, as a practitioner, that's the problem.
I understand the predicament you're in, but the question was really with regard to the judicial standards of judicial review.
Yes.
When the adjudicator decides that he has the right to base his order on what would have been given by the Superior Court, is that not a pure question of law that he should be correct on?
Well, I guess it gets, I don't know the answer to that. I mean, it seems to me you've got to give the adjudicator, or otherwise we're all going to be running around in circles, going to this court and that court and here and there. You've got to give them the authority to apply the law as best they can. And I think he did that here, and his decision ought to be given deference. And there's no basis just to say, you know, Mr. Spinney has so far convinced two courts that all the adjudicator could do was decide the notice period. That can't be correct. That can't be. Or 97, in 97, 2.1, and I know that he found in this case it wasn't disciplinary, but I'm saying surely he had the right to inquire into the real reasons for the action, or the reasons for the action. And if you say, no, the only issue before the adjudicator is the length of the notice period, then you do destroy, emasculate, blow up, whatever you want to say, 97 2.1. If that's right, if that's the correct interpretation, then 97 2.1 doesn't mean anything.
Well, it might be there for another contract situation. I guess what gets in the way here, at least in my mind, and perhaps I'm wrong, but is Section 20 and the at-pleasure appointment. And so an adjudicator has to work with the contract they have. And so 97 might well apply in another situation much more broadly.
Well, I mean, my position, Chief Justice, is that his contract of employment includes the Public Service Labor Relations Act. The relevant provisions, there are only a couple. There's not very much besides that, which it doesn't give him the right to seek a remedy, it obligates him. I mean, we've said in our brief, we believe Weber and O'Leary and Prairie Sound mean he had to seek his remedy in adjudication. He couldn't go somewhere else. And I realize those are under collective agreements, but he didn't have an option. He had to go there because of that provision when he's been dismissed. I'd like to give you an example where I think my friend's logic is completely wrong. If you remember O'Leary, now O'Leary was a case where there was a deductible, and the government sued him for he rented a car and he banged it up, and there was a deductible under the insurance, and the government sued him. And the court said, no, it's something arising out of the collective agreement, you have to go to arbitration or adjudication in that case. Now let's twist the facts a little bit. Mr. O'Leary, same facts, was not in a union. He was in a non-union position. And they deducted the money from him. Let's assume that. And he grieved that. He said, that's a financial penalty. You're going in. And they'd say, no, it's not for cause. It's not disciplinary. We just want to get our money back. And therefore, Mr. O'Leary, in my example, wouldn't have the right to grieve and adjudicate? That doesn't make sense. Remember, the section deals with discharge, suspension, or financial penalty. So can they avoid that? Like they're trying to avoid, they did avoid, well, they didn't in front of the adjudicator, thankfully, but since, they're trying to avoid any inquiry into why they took the action they did. Now, in O'Leary, in my example, all they'd have to say is, oh, you can't grieve. You can't go to adjudication on that. It wasn't disciplinary. We're not trying to punish you. We're just trying to get our money back. I mean, that doesn't make sense. That doesn't make sense.
But it seems to me that your argument is saying that when an employer tries to or wants to dismiss with notice, that's never really effective.
No, not saying that at all. Absolutely not. I agree, but what if that's not really what's going on? What's really going on is they want to get rid of this guy or lady for disciplinary reasons. That's what's really going on. But they can avoid an inquiry by an adjudicator by saying it's not for cause.
Him out. They're giving him notice.
Well, then but that's fine. Then just pay these people. We get rid of civil servants anytime. That's fine. Because all I'm saying is, do they not have an obligation? Does an employee who is terminated, does he not have a right, and doesn't the government have an obligation to justify the action? That's all I'm saying. And if the inquiry is made and they conclude that this is why they're doing it, okay, it's not disciplinary, fine.
Ordering council appointee can only be discharged for cause? Is that what you're
No,
saying?
I'm not saying that. We've contested this case on the basis that he's a legal officer in the Department of Justice. The ordering council, see, one of the problems here is we got to adjudication. He hadn't been removed by ordering council. He hadn't been removed by ordering council till after the first application judgment came down. And so if we'd said, oh yeah, we're going to pursue this because he was the clerk under ordering council, guess what? We object. He's not dismissed. He's not dismissed. We haven't removed him. So we're caught in a position we're not going to fall for that old chestnut. We're going to proceed on the basis he's an at pleasure legal officer in the Department of Justice, which he was.
Back to the procedural fairness issue. Is it your position that in the three actions that the adjudicator did refer to were disciplinary, even though he concluded in the end his termination was not disciplinary? Was there ever an incident where he was not given an opportunity to respond to the complaints about his work performance?
I can't. I don't want to say.
And just based on the adjudicator's decision. He never suggested that anywhere along the way.
No,
he did not have a chance to respond.
I think you're being very accurate, Justice Abella. He did respond to them, and that was one of the reasons the adjudicator found little or no merit in any of them. So he did have that opportunity. What he didn't have is the opportunity to address the employer if they're considering dismissing him. That's the purpose. That's what Justice Leroux Dubé said. The purpose of the Knight was to give the employee the right to address the employer and try to persuade him not to dismiss. That's as I understand the law.
Then what's the remedy for that? Couldn't you just the next day? Hold
Absolutely.
a meeting, do nothing, fire him again, and then it's a
Absolutely.
total waste of time?
Absolutely. No, it's not a waste of time. I'm sorry, but it's recognition of a common law right that these courts, your court has developed. But is there a permanence to it? Absolutely not. I quite agree on the fairness issue. I quite agree.
But let's get to the merits here on the procedural fairness. He writes her a 6-page letter on June 25th. He says he wants more specific allegations. She writes him a letter on July 21st setting out the specific allegations of concern. He then writes a response to her saying, I'm going to a lawyer. Where is the procedural fairness issue here? What has he been denied the chance to do?
All I can tell you,
Response
Justice,
to the complaint, even if it's true that they had to give him, that Knight strictly applies and they had to give him some ability to respond, what was this process stopped when he wrote the letter saying, I'm going to a lawyer?
well,
And the adjudicator said so in the next paragraph.
yes. All I can tell you is this, Justice Abella. He was not given the opportunity, he was not advised that they were considering dismissing him. He was not advised, no, but I mean, technically dismissing him, that this is apparent, and given the opportunity to try to persuade them not to do so. And it was found by Justice Stevenson that he would deny procedural fairness. I can't say any more than that. That was a finding of fact. Now, whether it's mixed fact, mixed law, I don't think should make a difference. I think his decision's entitled to deference. But Justice Boucher, if you don't mind, I've got to get back to that because you raised an issue and people may say, well, what's it to me? Who cares? The fact is, if you're entitled to procedural fairness and the action is taken contrary to that, and that decision then is void ab initio, assuming that's the law, and the person is entitled to reoccupy the office, yes, they could do it in the proper fashion, and that's been happened many a time. But so what? I mean, I don't think that's chicken smoke or whatever the proper language. I think it's important. That's why we have that protection, that procedural fairness protection. But it can always be overcome, revisited, and given to the person in question.
Well, I think it's a little peculiar here because of the nature of the right you invoke, the right to try to change someone's mind as a common law. Pretty strange,
Well,
I view.
well, it was a common law right in Knight. It's the same thing. They dismissed the person. It was a common law right in Knight. That's all I can say to that.
Can I go back to this question of you seem to be suggesting a kind of category approach in the sense you're dealing here with a labor arbitrator. Well, there's a certain purpose and function to that procedure, and you say that bringing it about with all of this fancy language simply undermines the utility of the institution.
Right.
There are other kinds of decision makers. I would think you would say the Minister of Labor acting under the Act on some general question of policy should have an even greater latitude of greater deference.
Yes.
Somebody administering, say, employment standards, whether you get holidays, the standard should be simply enforced. The Act should be closely supervised as a matter of law. But how does one distinguish between these categories? Because the only incident you've mentioned would be a privative clause, which gets us back to legislative intent, which gets us back into the functional and pragmatic test. So, first of all, am I right that what you're really urging, to the extent it's part of your argument, that the court deal in a kind of categories as opposed to all of these factors? And if that is the approach that you think is workable, what are the criteria for distinguishing among the categories?
I'd have to I'd have to put that in writing. I think it's too much for me to, I think it's too much. No, I'm sorry, I'm a simple person. I just think that if there's a privative clause, they're entitled to deference. You shouldn't, for example, if there's a rate-setting body, setting power rates or telephone rates or whatever, the courts shouldn't be there reviewing all that. That's not the role of the courts. That's why that body's set up in the first place.
But it goes back to the legislative direction. I
Absolutely.
think what the functional and pragmatic test attempts to pick up is that there's more to legislative direction than the privative clause.
Yes, and I mean, there is more, but at the end of the day, the problem is, of course, if you go on any other standard, and what's the standard if there's not a privative clause? I mean, how much deference do you give in that case? I know this court has dealt with the provincial court judges. That's simple rationality for the government's action, you know, on whether they. So there are all these tests out there, and I know the court's doing the best you can to come up with it, but boy, it's far from clear. And I mean, other than deference, that's all I have to say really is, if there's a privative clause, I think that there should be almost complete deference to the decision, unless it's off the wall.
Well, to take you back to a simple question, and without at all accepting your avowed simplicity, is it your position that an employer who is entitled to dismiss with reasonable notice can only exercise that power where the employer neither has just cause nor thinks that it has just cause?
No, that's not my position. No, my position is, under this legislation, if the government says, which is the case here, we're not claiming cause, we're dismissing you on notice, there is a right in an adjudicator to hear evidence to determine, is that true? Is that really, because otherwise, I can't get back, I have to go back to this union activity business. It's always been the law. The employer's not going to say, you're fired for union, but boards and courts don't accept that. They go into it. So all I'm saying is, they have every right to dismiss somebody not for cause, but the employee has every right to seek adjudication to determine if that's really what transpired.
Why
It
is
doesn't-
that?
sorry.
Why is that? Because
Because
they could have had cause and decided not to invoke cause. Isn't that part of the contract, that they have the right to fire without cause? I think this is the question Justice Fish is asking.
Yes,
We're
97,
denying the right of the employer under its own contract to hire employees that it doesn't have to invoke cause to dismiss.
97.2.1 is part of the employee's contract of employment out of the Public Service Act, as is 100.1 of the Act. That says if there was disciplinary action taken, the adjudicator can moderate the penalty. So that's why the adjudicator has to have the right to determine, was this in fact a disciplinary discharge?
You're
The key words are where disciplinary action was taken.
Yes.
As Justice Bastarash has just said, where an employer, whether or not the employer thinks that it has cause to take disciplinary action, chooses not to do so, but instead to exercise its right to dismiss with reasonable notice. I would like to understand on what basis one can inquire otherwise as to the adequacy of the notice, or whether the dismissal for with reasonable notice was instead a dismissal for a prohibited purpose, such as union activity, which is not an issue here.
No, it's not an issue here.
But that, can I just ask you a question about that? I find the comparison not terribly helpful to you, because when an employee is fired for union activity under a collective agreement, they don't have to have a meeting with the employee first. There's a hearing
but they're not-
afterwards to determine whether or not it was an unfair labor practice.
Yeah, but we're not talking about a public employer there. That's the
No, but you seem to be saying that procedural unfairness, the content of it here, is the right to be able to say to an employer before they're dismissed, you shouldn't fire me. That isn't the case for unionized employees
But
either.
in Knight, Justice LaRue Dubé, for majority, said that the procedural fairness applies to an at-pleasure employee